Cool, all right.
Further hearing in the Investec field.
Yes, Lord Guernsey, thank you for agreeing the timetable. Can we just make a timetabling change ourselves, which won't deprive you of any time, but for personal reasons, I think we need to rise today at 3:20. We'll give you 10 minutes extra in the lunch adjournment. In other words, we'll start at 1:50, and we'll give you half an hour extra tomorrow morning to make up. Start at 10.
Thank you, my Lord. I've noted that. My Lords, as the appeals have proceeded, the real issue, I would respectfully submit, that separates the parties is whether traditional protections of the beneficiary, and there are two aspects to that we'll come to, have in fact been overtaken or removed by Section 32. And that's what I want to focus on. Where one sees this, at least in part, is in the judgment of the Guernsey Court of Appeal of October 2014. At page 33, that's both the bundle hard copy and also the MS number. One sees it in several places, but I can pick it up from 45 and 52.
Which MS page?
33.
33, thank you.
So, to your Lordship see paragraph 45, the Court of Appeal gives its sort of combined interpretation of 1A and 1B of section 32.1. And importantly states that the consequence in their opinion is that in the case of a creditor, paragraph 2 has the effect, by reference to each aspect of paragraph 1, of entitling the creditor to have his claim settled out of such trust assets there are, including trust assets held by a subsequent trustee, notwithstanding any dispute which may exist that the trustee is in breach of trust. So that's one of the protections, is normally the assets would be protected in circumstances where and I'll come to how that is and the mechanism by which it's done, is in breach of trust. And the other protection is referred to in the following paragraph, which is the reference to Reed Johnston. And in paragraph 52,
Yes, what are you referring to?
Paragraph 52, it's
Yes.
the same conclusion that's stated there. Now, that deals with one of the protections, which is the question of breach of trust. It doesn't deal with another, though it appears that that is intended to be excluded also in the Court of Appeal's reasoning, and that is the protection against liabilities not reasonably incurred.
Yes.
So that I respectfully submit, that's the real issue between the parties, is whether those two protections for the beneficiary still exist, or whether the effect of Section 32, if it applies, has been to remove them. And our submission is that Section 32, if it applies, that's obviously the applicability question, the key words, or the key we submit, is that the words in Section 32.1a are words of limitation. They're limiting the right of the creditor against the trustee and therefore through the trustee to the trust assets, but they're not extending the rights of the creditor. Still less are they creating some new right for the creditor. And if there's time to get to it, that may be...
Or create some new right for the trustee as well, effectively, because the trustee, on the points you've just been making, is obtaining an indemnity when otherwise...
Yes,
it wouldn't.
that too, yes, indeed. We're saying that's not what this section does. if we have time to deal with the legislative history, though your lordships have got it in our written case in any event, one point we do make about that is that that the legislative history does not show that people were consciously considering whether or not to remove those protections for the beneficiary. So let me go through that. And just for the shape of my overall submission, if we are right that Section 32 does not have the effect of removing those protections, or indeed if Section 32 doesn't apply, as Mr. McQuater and we submit, then that takes one to the next stage of the debate, which is to consider, on that analysis, then it is important to know whether or not the liabilities were reasonably incurred. Neither court below dealt with the question whether they were, in effect, because on the facts, because Mr. Justice, Lieutenant Bailiff Chadwick took the view, we respectfully submit wrongly, that the words reasonably incurred in the statute meant some time before, and that was the debate my Lord Mans was having with my own friend yesterday afternoon. So that's why he didn't deal with it. And the Guernsey Court of Appeal didn't deal with that question because they took the view, as your lordships have just seen, that that particular protection no longer existed because of what Section 32 had done. But if either of those are wrong, if they're both wrong, then it is necessary to look at what, in fact, the position was in relation to whether those liabilities had reasonably been incurred. And we say, just so the lordships know what's coming, we say it's clearly within our notice of appeal that we complained that that had not been dealt with. And as a result, there is in a sense a gaping hole in the judgments below because they don't grapple with the question of whether the liability was reasonably incurred, save to the extent that the Court of Appeal said it didn't arise at all, and save to the extent that Lieutenant Bailiff Chadwick said it didn't arise because of the temporal issue. So I'll have to deal with that, and we'll want to take your lordships and make some particular submissions on Article 26, which is where the right of indemnity is qualified in that way, and have to say something about the facts. How your lordships then deal with it, we will need to consider at that stage. Another sort of preliminary point I make is that when your lordships come to look at the construction of Article 32, we will be submitting that the critical word is actually the word only. That's the important element of what Article 32 was doing, was to say that the rights extended only to the trust property, i.e. not to other property, and in particular, not to what I think my Lord Hodge described yesterday as the personal patrimony of the trustee, that is to say, property which was not part of the trust. It doesn't extend to that property, and that's what Article 32 we submit is doing.
You may be able to deal with this in due course, in which case don't let me take you out of your course, but can you help me with the questions that I put to Mr. McQuater yesterday? How do you submit that this actually works? Is the limitation to the trust property a limitation on the claim, so that, for example, you would plead by way of defence with the trust property is no more than X? Or is it a limitation on enforcement? Do you claim the full amount, and the limitation to trust property then applies at the stage of enforcing your judgment?
My Lord, I see, of course, and I should have come prepared.
Well, if you're going to deal with it at some later stage, I'm perfectly happy with that.
Just put it.
It's quite difficult to see how it could be actually a limitation on the claim, because you wouldn't have a clue at that stage what the trust property was worth.
Yes.
Well, that's absolutely right. Linguistically, it looks like that, but it's hard to believe that that can have been intended. I mean, the other problem, which you may also like to consider at some stage, is one possible interpretation of 1A is that without actually creating a separate legal entity, i.e. the trustee in his capacity as a trustee, the provision can only actually work if for certain purposes the trustee in his capacity as a trustee is treated as legally distinct from the trustee in his personal capacity. Now, if that analysis is right, it may be the case that this is to be regarded as part of the constitution of the defendant, and therefore, at least arguably, a matter to be referred to Jersey law regardless of the
Yes.
Of the proper law of the obligation.
Well, I understand the proposition. It's the predicate that we don't accept. We respectfully don't accept that what this does is, as my lord has just put it. It's not.
Well, I put it purely by way of questioning.
Yeah, I understand
That may be the critical question. How does this work if it does not create a legal distinction between the trustee in his capacity as such and in his personal capacity?
My lord, obviously I'm going to come to this, but let me just in short say the position. We say the traditional position was that you get at this through the trustee. So the creditor has a claim against the trustee because it is the trustee who has contracted or committed the wrong, whatever it is that gives rise to the liability. Mm-hmm. The trustee has a right of indemnity against the trust assets, which is limited in certain respects. It's limited by whether or not the liability was reasonably incurred. That's common law, but it's now in statute. In any event, in Article 26.
Well, that's what effectively B produces.
Well, no, my lord, no. This is a separate question. That's a question of whether or not whether this is a knowing creditor or an unknowing creditor. What I'm saying is the mechanism for this is, in our submission, as it's always been, that the claim is against the trustee. What the statute does is it gives some protection to the trustee, and the protection to the trustee, and indeed to the trust estate, the protection is by those words, extend only to the trust property. But it doesn't create a new right to go against the trustee or the trust property, because that follows from the contract or the fact that the trustee has committed a wrong. What it is saying, and I think we will submit, and I will come back to this, it becomes clearer when one examines this against the case law, particularly I want to take your lordships to some of the 19th century case law, just because it sets out clearly what the position is. You claim against the trustee then has a right of indemnity, which is qualified in two respects. If he's committed a breach of trust, he can't, unless and until he's made good the trust, he can't claim the indemnity. And it also prevents him being indemnified against liabilities which are unreasonably incurred. The position of the creditor is the creditor will receive the benefit of that, either through directly claiming against the trustee, but also because the creditor will have a right of subrogation to the trustee's rights, and those rights of subrogation, we say, are qualified in the same way as the right of the trustee to be indemnified is qualified.
So the mechanism that you go by the trustee, who then relies on his right of indemnity, you say applies in the same way to both A and B,
yes,
although it's only expressly referred to in B.
It's only expressly referred to in B, that's perfectly true, but it has to apply in A because that's the only route. That's the only route by which you can get at the trust property.
In your submission?
Well, my lord, in my submission, but also unless it is being said, and of course I understand the premise of my lord's question, unless it's being said that what this has done, without ever saying so, is to create a new legal entity, namely a trust, which has some special characteristics, then that's the way it has to be done.
Yes, well, I mean, the bit of that sentence which begins unless seems to me to be at the heart of the case. I'm not sure you have to go as far as to say it's a new legal entity, simply that Jersey law, as part of the constitution of trusts, requires a legal distinction to be made between the two capacities of a trustee of a kind which doesn't exist in England.
Well, which doesn't exist in England, and I know that it's reliance is placed by the former trustee on the US law, that isn't actually developed in the submissions before your lordships, I would respectfully say, in a way that enables you actually to be comfortable in relying upon that. And we've produced overnight an extract from a work by, but it's by Professor. I know, but it's a book that's edited by, which discusses what the position in the United States is, and it's much less clear than I think my learned friends would want to suggest. But the problem simply is this: for your lordships on that, to say, yes, we recognise that there is a new concept on the basis of that, would require a more detailed analysis of what the foreign law, the US law, actually says and how it comes about. Some of it is statutory, some of it is a result of case law, which we haven't got.
Well, it's only relied upon as indicating that it's possible to do such a thing and maybe desirable to do it. Ultimately, we try to work out whether that's what they've done.
Well, in my submission, they haven't done that, and there's no need for them to have done that, because it's perfectly possible to give effect to the intention behind this. And the intention behind this is to distinguish between, I'm going to use my Lord Hodges' words, distinguish between the patrimony of the trust and the patrimony of the trustee, and to exclude the patrimony of the trustee from the resources from which the claim can be met. I will take, my lords, I think, to some of the cases. Right, I see, my lord.
I wonder if that is consistent with your idea of a cap, because my understanding of the cap was that there remained a personal liability on the trustee, but it was capped at the value of the trust estate. If you are giving the meaning to the final words in A, that the liability of the trustee is only in respect of the trust patrimony and can only be realised out of the trust patrimony, then the position of the creditor is that he or she will have a claim against the trustee, have no recourse against the personal patrimony, and on your approach will have no recourse against the trust property if the beneficiary is complete breach of trust. That seems to be the consequence of your submission.
My lord, I understand that, and my lord is right to draw attention to that, because I think that the way this has developed does raise a question whether we were right to say all this does is to impose a limitation of liability. We certainly say, we've always said, that what this does is to limit the availability of the creditor to have recourse.
Yes.
We've always said that.
But is it still your case that it is a limitation on personal liability, or are you accepting that the final words in A mean that the only patrimony against which the creditors can proceed is the trust patrimony?
My lord, what I'm submitting is that all that this does is not, that's what I'm trying to get at, is not to remove the protections which the beneficiary has for the two rules I've identified. That's the critical point.
Yes. I appreciate that it is perfectly consistent with your protection of the beneficiaries that you can depart from cap on personal liability.
Yes.
But I was just trying to ascertain whether you were, in fact, departing from cap on personal liability.
Well, my lord, it is a cap. It does cap the liability, but what I'm accepting, in the light of the way the case has developed, is actually 32(1)A is not actually doing anything that's new in terms of giving access, as it were, to the trust estate. What it is doing is clarifying that in the case that it identifies, it's only in that respect. That's the limitation on what the creditor can do. He's limited to that right, and that's the significance of the word only.
Yes.
But can I...
Thank you.
Of course I don't... So can I get to this? My submission is the starting point to understand this is to look at what the traditional position is. And it's relevant to restate that for two reasons, because it's important to understand what we mean by personally liable and representative capacity. And it's also important to look at the previous law, because that helps to explain what it is that the statute was seeking to do. I just want to make some pretty basic propositions, but I'll rattle through them. First is the trust is not an entity. And the Court of Appeal stated that impeccably in their judgment of October 2014 at paragraph 27, and I don't, paragraph 23.
Paragraph 27, yeah.
I think it's page 27, it's paragraph 23. And they said, so the starting point is the trust is not a separate entity. In the later case, which is RZ Trust, which your lordships have at volume 28, tab 394, and MS, page 30703, that's Commissioner Clyde Smith's decision following, at least in time, the decision of the Court of Appeal in Guernsey.
Did you give a reference? 30703. 307.
He says at paragraph 3 that to talk of an insolvent trust is, of course, a misnomer. A trust is not a separate legal entity, cannot, as a matter of law, be insolvent. And describes what is meant by that. And that, in fact, was what the Guernsey Court of Appeal themselves were saying. They didn't suggest that the trust was a separate legal entity. And in our submission, the next basic proposition that follows from that is you can't sue something which is not an entity. Therefore, you must be suing the trustee. And I understand my learned friends accepting that now. I understand Mr. McQuaid to be accepting that yesterday, that it's the trustee who gets sued. Now, against that background, one then needs to look, in my respectful submission, then against what the protections for the beneficiary are at common law. Could I ask your lordships, first of all, to take the decision in Muir, which is to be found at volume 11 of the authorities, at tab 126, page 23946. Tab 126 then. And this is relevant for two reasons, both because it shows what the common law position was, but also is, we would submit, the origin of phrases that are then used in the Jersey law. So in the speech of the Lord Chancellor Earl Cairns, at page 355 of the report, 23964 of the electronic bundle, he poses the question whether in any particular case the contract of an executor or trustee is one which binds him personally as to be satisfied only out of the estate of which he's the representative, or and that is a question of construction. So if it is, this is a limitation which is imposed by contract, then it's a question of construction. And what this case demonstrates is that using the words as trustee don't of themselves have that effect. It doesn't have the effect of saying that this is only limited in that way. It's not necessarily a limitation, though it may be depending on the construction.
That's contractually.
Yeah, my lord, contractually. But what's, we say, significant is that the way that it's described, for example, at the bottom of page 361, page 23970 of the electronic bundle, and over the page, is the description of liability as trustee. So Lord Cairns says, Colonel Gordon might have insisted they should be personally liable to him, or he might have agreed that they should only be liable as trustees, i.e. to the extent of their trust funds. They professed in one part of the instrument to contract as trustees, another as trustees only. Obviously, they meant in both places to contract in the same way. Further, if these words as trustees and as trustees only were not introduced to limit liability, there was no other purpose in the deed which they could possibly serve. What I'm getting at is, in the case of limitation by contract, if you use the words as trustee, it may or may not have the effect of limiting the liability, but it's shorthand for what that means. Is it only to the extent of the trust funds, is perfectly properly described as liability as trustee or only as trustee. And those obviously are words which then we then get to see in section 32, not the word only, but in that place, but as trustee. And that is the distinction between that and personal liability, which is the situation in which the whole of the trustee's personal patrimony, personal estate, is placed at the disposal of the creditor. If we could look at Lord Penzance on page 372, page 23981 of the electronic bundle, the Lordships will see in the paragraph which starts with a reference to the Lord President, then saying that Lord Dare said the grounds in Lumsden resolved themselves into this, that where trustees join in a contract of partnership for trading purposes, such as a contract carrying on the business of banking, the mere designation of them as being trustees will not exempt them from the same personal liability as is undertaken by the other partners. So this is the contrast that's placed between as trustee and personal liability, but of course it is in the context of a contractual limitation, and actually what's being said is not there's a different capacity in which they're liable, it's saying what the extent of their liability is. And that's the same dichotomy which we say then finds its way into section 32. I'll come back to that. Can I, just to make that, and underline that, can I take your lordships to one other authority, which is the authority of Watling and Lewis, which is to be found at bundle 30, tab 430. Watling and Lewis, it's 31365 of the electronic bundle. Decision of Mr. Justice Warrington.
Sorry, what was the MS number again?
MS number starts 31365. And the relevant fact in that case, and one sees it from the head note on page 31365, MS 31365, was that by a deed, the defendants contracted, as your lordships will see the words, as such trustees, but not so as to create any personal liability on the part of them or either of them. So as trustees, but not so as to have personal liability. And that was what came before the court, as to whether or not what the effect of that was. And if your lordships will go to page 423, MS 31374, the whole of the bundle.
Yes, the whole by which it is.
It should be bundle 30.
Extreme left.
30.
No, I mean on the electronic one.
Oh. Can we hand up a hard copy to your lordship?
No, I mean, I much prefer to watch it on the...
I understand that.
To get to the page when you give me the page. Just if one of my colleagues can tell me what
If you click on the Adobe thing and go to the extreme left one, that's one particular.
The page is 31365.
What is this bundle? What is the electronic bundle called? Do we know that?
It's the Investec.
Investec Appeal.
Investec Appeals Electronic Bundle is the title.
It's the first one of the whole library.
You've got a series of electronic bundles, and they all have slightly confusing names.
I've got about, Exactly right. I think I've got it again now. It did, for some reason, it deleted itself and left everything, all the smaller ones. Right, thank you.
Happy to deal with one case. I hope your lordship's not asking me to deal with another.
I've recovered
This
it.
case has about 15 different electronic bundles.
Oh, I see. Right.
Yeah, no, I was looking at the list, bewildered as to which one it was.
The same happened to me yesterday. I lost it and got it back.
I'm glad that your lordships have the. In any event, I hope that I can take your lordships now to page MS 31374 or 423 in the report.
Yeah.
And Mr. Justice Warrington sort of posed the question how the covenant was to be construed. Do the words of this covenant purport to limit the liability of the defendants or to destroy it altogether? They purport to destroy it altogether. In the first place, the words referring to personal liability are but not so as to create any personal liability. That is, no personal liability of any kind is to be created by the covenant. And is any light thrown upon these words, any light in the sense of an indication that they're not to be construed so widely, by the preceding words of such trustees. These words of such trustees, again, in a covenant of this kind, have no effect at all. A covenant by a person as trustee does not render his trust estate liable. It is a covenant by himself. So although language as trustee and personal liability is being used, what's actually being said in these cases before we get to the statute, what's being said is that an appropriate way to describe limitation of the liability to the trust estate, or not limiting to the trust estate, is to say on the one hand, as trustee, and on the other, personal liability. And that's, when talking about personal liability, it doesn't mean that there isn't personal liability in the other case. There is personal liability, though it's capped. And that understanding, we respectfully suggest, helps understand the language which is then used in Section 32.
So it's an attempt. What was the context in the Justice Warrington case? The term appeared in a deed with a third.
It was a deed, whether it was void, because on the one hand they said no personal liability.
Yeah.
As Justice Warrington said, well, you can't do that.
Yeah.
It is a personal liability, though it may be capped.
But what Article 32 is doing is seeking to do something which in all these cases you've been showing us has been done contractually. It makes sense if
Yes,
it's done
yes, quite.
contractually.
Yes.
When you have a statute which attempts to do something which a contract would normally do, then you ask, I suppose, what contracts does it apply to, which was what we were discussing yesterday.
Yes, indeed.
You might also ask why the statute would bother if it achieved no more than the parties could achieve by contract anyway.
Well, my lord, no. This is important, because what the statute is saying is, if you know someone's acting as a trustee, we're going to give you, creditor, this, or give you beneficiary, indeed trustee, this protection. If the other party knows that you are contracting as a trustee, then they are limited in their claim in this way. And if they don't know, they're not. Whereas otherwise, to leave it each time to agreement of a particular contract would indeed, as these cases show, be a matter of uncertainty. Quite what language you use, does it achieve it? And of course, do you do it every time anyway? And what lies behind this, no doubt, is the regularity with which trustees are entering into transactions, run-of-the-mill, mundane transactions or more than that, and whether or not that engages their personal liability in the sense their personal assets are put at risk.
Can you contract out of 32(1)(a)?
I don't think there's anything to suggest you can.
So you submit you can't?
Yes. Yes.
So it's not open to a trustee who is known to be acting as a trustee to assume a greater liability than 32(1)(a).
Well, put that way, my lord. I'm not.
Well, that's the implication of what you've just said.
In which case I need to modify what I just said, because I can't see why a trustee could enter into a contract which says, even though you know I'm a trustee, on this occasion I am going to put my own personal assets behind this, and obviously the court would have to construe the contractual obligation, but if it amounted to saying, in the event that this undertaking is not honoured, then you can have a recourse to me personally, then that can be done. That's not quite the same, which is why it's as saying we hereby contract out of Section 32, though maybe that might be a short
Well, he can make himself a co-obligant personally.
Yes. Yes, my lord, he could.
And if that's right, then Article 32 does that which parts of the 1925 English property
Beg
legislation,
my Lord's pardon.
then Article 32 may do that which parts of the English 1925 legislation did, namely write in as the starting point that which was often much earlier spelt out in lengthy provisions in conveyances.
Yes, my Lord. Yes. And what it is, when I come to sort of develop it, what it is doing, though, and that's why I say the critical word is the word only, is it's emphasising that that's only when it applies, when there is a knowing case, so be on your guard, creditor, that the claim will only extend to the trust property, not to the trustee's personal other. Now,
But be on your guard, which creditors?
well,
You take the same view as Mr. McQuater. You apply ordinary conflicts principles.
as to whether this applies,
Yes.
yeah, we take the same view as Mr. McQuater that actually in the context this statute does not apply, because what matters is, in this context, what we're looking at is the law of the obligation, and the obligation is the loan or whatever it may be. But we do, and we've said this in our printed case, we do recognise that if the statute has different effects, then that may give rise to different questions of conflict, which is why we thought it was right yesterday when one of your lordships says, don't you have to start by discovering what it is that Section 32 is supposed to do before you can be clear what is the conflict which applies to it. What you don't have, in our respectful submission, you don't have some special new conflict rule which relates to this sort of situation. And if you find yourself, not your lordships but my learned friends, having to say something like that, it does rather indicate that their starting point of what the obligation, or what the statute actually does, may well be wrong. Can I just, I've it so often happens, but I have no complaint. I just want to try and just fill in. There are some little gaps in what I've been saying, which I hope may help make it clearer. So the traditional way then that the creditor gets at the assets is, as I've said, is by suing the trustee. What does the trustee do? The trustee then has a right of indemnity or a right of exoneration. Now, we haven't talked about the right of exoneration yet. So the right of indemnity is what Article 26, which I'll have to say quite a lot about later, Article 26 does. But the right of exoneration is the ability of the trustee to take the trust property and apply it to that obligation. So the trustee doesn't have to go through a process of formally claiming indemnity. The trustee, who has, in any event, access and control, no doubt, over the trust funds, is able to take trust funds and apply them directly to the liability, and that would be described as the right of exoneration. And that's, we say, what Section 32 is, 32(1)(a) is recognising. It's implicit that that's what the trustee would do, would be to take the property, and a trust property, and use it. But then this all becomes, and I'm sure your lordships have my point, but it's critical to this analysis, that all becomes the ability of the trustee either to claim indemnity or to claim the right of exoneration is dependent upon the conditions for that, as between the trustee and the beneficiary being satisfied. And that includes, critically, Article 26, and critically also whether or not the trustee is in breach of trust.
I mean, I'm not sure I grasp it, the difference between a right of indemnity and exoneration, as you say, I mean, isn't it?
It's whether it's reimbursement or you...
Yes, I see. It's actually using in the first place the trust funds to meet the claim.
Yes. I give my lords a reference to Lewin, which describes it in that way. I've got it at my fingertips. Is that all right? But in both cases, we would say, so far as the creditor is concerned, and I'll take your lordships to Sonny, which quite helpfully sets this out, the creditor will have a right of subrogation. So if I could take your lordships perhaps to a convenient source just to set that out. It's in volume 17. have a look under here. Right, it's volume 17 at tab 237, which is MS page 26611. And it's a consultation paper issued by the Trust Law Committee. And your lordships will see
This is
on...
a Jersey document, is it? Sorry.
No, no, it's English.
This is English.
It's
Okay.
English.
Which tab again, sorry?
Tab 237. And your lordships will see on MS page 26612, which is the second page in the hard copy, lordships will see that this is consultation is issued by Lord Brown Wilkinson, but your lordships will notice underneath that the responses are to go to Professor David Hayden. So he was obviously critically involved in this process. And Professor Hayden, obviously, a great expert in the area.
What was the trust, or is the trust law?
I beg my lord.
What is or was the trust law committee?
I don't think it was
Mr. Torp saying he is the trust law.
I think he that's a little degree of aggrandizement. I think he was on the committee, whether he constituted the whole committee. But in any event, what the preface by Lord Brown Wilkinson gives some indication as to its purpose of looking at the existing law, and I think considering whether there should be changes to the law and making recommendations. All I want it for is just because it's a convenient source at page 5, MS page 26618, sorry, 2616, at page 3 of the report, paragraph 2.5, which starts to consider the trustee's right of indemnity. The right of indemnity is the right to be reimbursed out of the trust fund for money properly paid out of T's own pocket, or a right to be exonerated from paying out his own money through the power to pay due debts out of the trust fund. So that's the two expressions, reimbursement and right of exoneration. And then the next paragraph, T's entitlement, trustee's entitlement to be indemnified out of trust assets for payments actually made and liabilities incurred in the due administration of the trust entitles him to retain the trust assets or an appropriate part of them until his claim for reimbursement or exoneration has been satisfied. And then at paragraph 2.33, which is MS page 26619, where T is personally liable, the creditor has no problem if T is good for the money. However, a common law judgment cannot be levied against trust assets as opposed to T's own assets. When the common law remedy was going to be fruitless because of the insolvency or poverty of T, it became possible to maintain a bill in equity against T, or T's successor as trustee, for equitable execution, so that X's claim could be satisfied out of the trust assets that could not be reached at common law.
Why, as a matter of interest, forgive my ignorance, couldn't you execute judgment at common law against trust assets?
Presumably because the trust is not a legal entity, so you have to go against the trustee.
Wait a minute.
But they're vested in the trust.
They belong to him. That's what you would expect.
Yes.
Well, in bankruptcy, it's certainly the case that trust property doesn't vest in the trustee.
Yes.
For the satisfaction of the bankrupt's creditors, at least in England, it doesn't.
Oh, I can see that, because
And I
that's trust
suppose
property.
if that's right, then maybe there is a principle that you can't execute short of bankruptcy on your debtor's trust property. But I'd be grateful to have it set out and explained, because it's, in one sense, the palimpsest or other side of the canvas to a trustee insulating his own patrimony from a claim against him as trustee.
The point, I know your lordships understand this, the point I'm trying to get at here is actually not the detail of why there cannot be a claim against the trust assets directly, but the question of how the creditor gets to the trust assets and when he's entitled to, and that is done through being subrogated to the trustee's right to indemnity. And the significance of that we do refer to this in the printed case, but the significance of that is that if the creditor is able to get at the trust assets through subrogation to the trustee's right of indemnity, then two things follow. One is that if Section 32(1)(a) is saying that the creditor has a right to get at the trust assets, it's not actually saying anything new, because that's already what the position is. And the second thing that follows is obviously what underlines the submissions I'm making, is that the way in any case that you get at the trust assets is through the trustee's right of indemnity or exoneration, and that is subject to the limitations that the trustee cannot get an indemnity against a liability not properly incurred or reasonably incurred. The language differs, but it's the same concept. Nor can the trustee get an indemnity or exoneration where he is in breach of trust. And those are fundamental propositions in relation to the right of the trustee, and that is why it's important, and I recognise the point my Lord Sumption put to me before, that the right is exercised through the trustee. The creditor is in no better position than the trustee. Now, it's possible to anticipate a question. Of course, it would be possible for statute to change that. Statute could say, well, actually, we're going to have a different rule from now. What we respectfully submit is that's not what this section does. It doesn't say that it does that. All it is saying is there is some limitation on our rights, the rights of the creditor, and those limitations are indicated by the word only.
So the effect is that if the trustee has no significant personal assets and improperly accrued liability relating to the trust will effectively be unenforceable altogether.
It will mean that there's two elements of that, if I may say. So firstly, so far as the trustee is concerned,
he has no right of indemnity. You can't get at the assets directly. So there may be an impropriety of motivation, for example, of which the counterparty is completely unaware, but he is the sufferer by it unless the trustee has enough personal assets to discharge the liability. Is that the position?
There is a qualification to that because, and Lordships haven't seen this yet, but Section 54(4) of the, I think we looked at it, but not perhaps with this in mind, Section 54(4) of the Jersey law, which Lordships have at MSA 20443.
20443.
Mm-hmm.
And I think it may also relate to the question my Lord Briggs posed yesterday, but where the trustee becomes insolvent, the trustee's creditors have no right or claim against the trust property except to the extent that the trustee himself or herself has a claim against the trust or has a beneficial interest in the trust.
Sorry, where are you reading from?
From 54(4) on page 20443
I see.
of the MS.
Thank you.
Or is this the Jersey or the Guernsey law?
Jersey.
This is Jersey law. It's the same law as the section.
Right, thank you.
Yes, but that is a traditional provision, is it not? It separates the trust patrimony from the debts of the trustee qua individual,
But
or his personal debts.
what it does, my Lord, is critically says that you can only get at the trust assets if to the extent that the trustee himself has a claim against the trust or a beneficial interest in the trust. And two things flow from that. One is, how does this fit with what is being said about the effect of Section 32(1)(a)? It's being said, and this says the critical question, that 32(1)(a) or 32(1), certainly 32(1)(a) gives a right to indemnity even where the trustee is in breach of trust, even though the trustee wouldn't have a claim to indemnity himself in those circumstances. It's a direct contradiction then between this and that. And the second thing that it demonstrates is that the statute draftsmen have thought through what the situation is about insolvency as well. Yes, and there's no distinction. The words "the trustee's creditors shall have no right to claim against the trust property" do not distinguish between a claim against the trustee because he was a trustee or entered into a trust obligation and against the trustee in a personal capacity. In either case, the statute says no claim except to the extent the trustee has a claim himself. So that is, my lords, how we say how the thing it worked before the statute. That is to say that there's a claim against the trustee. Whether it's limited will depend upon how the contract has been worded and agreed. If there is a claim which is limited in some way, then or whether there isn't, the creditor will have a right of subrogation to the right that the trustee has, and that is subject to the two beneficiary protections that I've identified. One is Article 26, no liability, no reimbursement unless the liability has been reasonably incurred, and the rule that the trustee can't be reimbursed and can't claim exoneration if he's in breach of trust, unless and until he's reconstituted the trust. And the question for your lordships, where we respectfully say the Court of Appeal got it wrong, was to say that Section 32 has removed those two protections. And our submission is there's nothing to indicate in the wording of the statute that they have, nor, and I'm not going to have time to go through the legislative history, though your lordships have it in,
Got it in your
in printed case, yes. There's no indication there that there are questions there. There's no indication there that anyone said what we are doing now is we're removing these important protections from beneficiaries. Put it at its lowest, it would be surprising if that is what this statute has done.
Is a possible reconciliation of the apparent tension which you seek to draw between Article 54(4) and Article 32 that the reference to the trustee's creditors in subsection 4 doesn't include those who have contracted with the trustee knowing that he's a trustee, and so are not in a sense his creditors in the sense of people who have any access to his patrimony?
Well, my lord, the words in our submission need to be taken as they are, and the plain meaning of the words is creditors in both capacities. They're still the trustee's creditors.
Well, the trustee can only be insolvent in his personal capacity, surely.
Yes, but he may be, that is true, he can only be insolvent in his, well.
How could he be insolvent in relation to a debt owed under a contract where he contracted as trustee and which didn't affect his personal estate? I mean, his insolvency would be irrelevant to it, wouldn't it?
Well,
because the
he's insolvent.
affects his personal patrimony.
The claim has to be brought against the trustee because there's no one else against whom it can be brought, and he is insolvent, he is insolvent. The question is what happens then, and the statute tells one that in those circumstances, the claim against doesn't extend to trust property, except to the extent the trustee himself has a claim against the trust or a beneficial interest in it. And therefore, if he doesn't have a claim, because that could be a claim against the trust assets, would be the indemnity, classically.
But if you accept that the words in 32(1)(a), the concluding words, shall extend only to the trust property, excludes the personal liability of the trustee, then his liabilities qua trustee will be irrelevant to his personal insolvency.
But, my Lord, the submission that we make is that one has to be careful about these words, personal liability and as trustee, and that's why I was taking your lordships to Muir, and I'm going to just give your lordships references to, taking your lordships to Watling, I think, already.
Yes.
And there are two others as well. Move that out of the way. And what's running through these cases is that the language which is used, admittedly in the context of construing contracts, is to distinguish between a liability as trustee and a personal liability. But what is meant by that is which assets are exposed to that liability, and indeed what the extent of the liability of the trustee is. Yes. And so when one comes to see the Jersey law, it not looking in my respectful submission, in our respectful submission, that anyone thinks that they're doing something more, and if they were, the words are very, very weak to achieve that. They're perfectly adequate. These words are perfectly adequate simply to say it extends only to the trust property and it doesn't go any further. And that's the most important word, once you've satisfied yourself that the trustee is acting as a trustee, is a protection for the trustee that it's only against those assets that anything then runs.
So his personal estate is not exposed under Jersey law. His personal estate is not exposed to the obligations which he enters into qua trustee. Is that the present trustee's position?
That's the effect of, yes, that is the effect of the submission.
And is that consistent with the case that was pleaded about it being a cap?
Well, I recognise the point that my Lord makes about that, but in the course of considering the arguments that are being raised, one has to, and the emphasis that's been placed on on these words, it's important in our submission to recognise that there is already an ability to get to the trust property through the right of contribution and the trustee's right of indemnity. Yes. And what's being said is that's the only thing that is exposed.
Yes, I mean, it's not necessarily to say that 32(1)(a) means that there is no personal liability on the trustee is not inconsistent with your submission that the access to the trust property is still constrained.
That's right.
By more general trust law. I can say that.
And what your lordships have got the point. By looking at the 19th century cases and the language that they use, and I give my lords a reference to two others, which we submit help in the same way, what the statute is doing is it's using the shorthand that one gets from those cases, shorthand being as trustee, meaning only the trust assets, and personal liability, meaning at large. But in both cases, there has to be a personal liability of the trustee, otherwise there's nothing to enforce. So we respectfully submit that so far as the Court of Appeal is concerned, to have got to the position of saying that those protections have disappeared is unsupported by the wording of the statute, or indeed reasoning. There's no reason why those protections for the beneficiary should have disappeared. Article 26 is still there. Article 26 doesn't suggest in itself, I'll come to it in a few moments, doesn't suggest that it doesn't apply where Article 32 applies. I parenthetically make this point too, that insofar as an analogy is drawn with the position under US law, which my learned friend Mr. Taub does, and he does that at his written case, Appeal Documents 2, tab 32, that's MS page 14161. Insofar as one can determine from the materials currently before your lordships, which are not extensive on US law, it does appear that the right that's there referred to does not apply if the trustee did not properly enter into the liability. In other words, at least that protection still applies under US law. And if I give a reference to that, my lords, that's in there's a supplemental bundle of authorities, and I worry that well, actually, first of all, in authorities bundle 33, that may be sufficient. We have the restatement at tab 476, which is MS page 32245. And we see it two places, at page 94, which is MS 32246, in the restatement. First of all, it talks about the now prevalent doctrine in the United States reflecting common law and statutory concepts. So one would have to examine to what extent the principle derives from statute, and whether that's similar or dissimilar to the statute we're considering here. And then at the bottom, penultimate paragraph, under the modern approach adopted in this chapter, third parties may proceed against a trustee in the trustee's fiduciary representative capacity, whether or not the trustee is also personally liable, with the trustee shielded from personal liability insofar as the trustee acted properly.
Sorry, which page are you on?
I'm on page 94, page MS 32246.
Okay. Yes, I got it. Thank you.
And one sees that reflected again in the commentary at page 100, MS 32252. The reporter's notes in the left-hand column, in the first paragraph, whether or not the trustee is personally liable, with the trustee protected from personal liability to the extent the trustee acted properly. And it actually makes a reference to the Uniform Trust Code at section 1010. We actually have that now in the supplemental bundle of authorities. I'm not sure yet there is a...
It's actually in this quotation from Scott in volume 32.
There's something helpful, I'm sure, but I can't quite follow it. I just want to note that in the supplemental volume of authorities, which I don't know whether your lordships now have an MS number, it's tab 19.
I think it's in electronic form. Does it have page? It has its own internal pagination, I think.
415.
Thank you.
And the statutory section, section 1010, is except as otherwise provided in the contract. A trustee is not personally liable on a contract properly entered into in the trustee's fiduciary capacity in the course of administering the trust if the trustee and the contract disclose the fiduciary capacity. So the point I'm making is that assuming that your lordships were sort of content to draw an analogy from the US position, that has not excluded this important protection that we now have in Article 26 of the current law, but still applies. So if, my lords, we can look, please, at what the Court of Appeal said. Let me tell you what my learned friend said. That's in the October 2014 judgment.
MS.
It starts really at paragraph 38. Page 31. It's also the MS page as well. Paragraph 38. We see no basis for the contention that subparagraph 1A has also created a direct court of recourse to the trust assets in favour of the other party. So the court was rejecting the argument there's a direct claim, though, as I've shown your lordship in the case, through the subrogation to the trustee's right of indemnity, there could be such access even before the statute. And we respectfully say these are the paragraphs that deal with it. One doesn't see between there and 45 why it is the protections which are described as in Re Johnson, paragraph 46, page 33, have gone. Can I take your lordships to Re Johnson? The reference to which is temporarily escaping me. Volume 1.3, tab 151, which is at page 24834. I wonder if your lordships would look in the judgment of the Master of the Rolls, Sir George Jessel, on page 2438, about partway down.
Electronic page?
Page 24838.
Yeah.
There's discussion towards the end of the page about the court putting the creditor, so to speak, in the place of the trustee. But if the trustee has wronged the trust estate, that is, if he's taken money out of the assets more than sufficient to pay the debts, and instead of applying them to the payment of debts, has put them into his own pocket, then there is no such equity because the Settee Trust are not taking the benefit. And then on page 555, which is MS page 24841, about just over two-thirds down, what is the nature of the right of the creditors against the assets specifically appropriated by the testator for the purpose of carrying on the trade? I'm thrown back on the authority of Lord Justice Turner if the right of the creditors is the right to put themselves, so to speak, in the place of a trustee who is entitled to indemnity. Of course, if the trustee is not entitled, except on terms to make good a loss to the trust estate, the creditors cannot have a better right. And we, with respect, do not see anything in the Jersey law which says that right or that limitation is being removed. Nor do we see anything, and that's what I want to come to now, is Article 26. That says the limitation in Article 26 does not apply. A trustee may reimburse himself for all expenses and liabilities reasonably incurred in connection with the trust. So reasonably incurred is the condition for reimbursement, and also we would submit by necessarily also to the trustee using the monies through his right of exoneration directly from the trust estate. So the two questions are, what is it in Section 32 that has removed that limitation, or has removed the Ree Johnson limitation that the creditor's right is no greater than that of the trustee, and if the trustee isn't entitled because of his breach of trust, then the creditor can't reach through him to the trust assets.
Court of Appeal didn't address how they read into Section or Article 32 the exclusion of, the exclusion of the common law rules which you've mentioned, in particular the rule that you don't get an indemnity or exoneration in respect of liabilities.
I think it was the contrast between 32.1a and 32.1b, and I think it's paragraphs 40 to 42 and 44 in the October judgment that addresses this matter.
But I think my Lord Hodge is right. That's all it turns on.
I think that is the
They do, yes, well, obviously, he's reading quite a lot in as he was walking.
Well, it is, and indeed it's entirely explicable why it is drafted in this way, the contrast between A and B, because in the ether of discussion about this, there's this dichotomy which we see from the cases between liability as trustee and personal liability. It's logical then to have one of them dealing with liability as trustee, which is A, and one of them dealing with personal liability, which is B. But as Mr. Justice Warrington's case shows, it's not, of course, true that there isn't personal liability in both cases. It's just of a different order. So, looking at it this way, it's perfectly explicable what's taken place. What the section is doing is saying, right, if you know that the trustee is acting as a trustee, then your claim is limited only to the trust property. Can't go beyond that. But if you don't know, what happens then? Well, if you don't know, then you have personal liability, which we know from the dictionary, as it were, in the other cases, means extended unlimited liability, and all your assets are at risk. But as soon as you say that, as soon as you say the claim may be made against the trustee personally, you need immediately to go on and say, but that doesn't mean you lose your right of indemnity. The risk would be if you had just said, you'd stopped it, maybe the other party may be made against the trustee personally, that might have been thought to itself to have excluded the right to indemnity. So,
was the Court of Appeal saying under B that a different rule applied as regards the extent of the right of indemnity in a case where there had been unreasonable incurring of liability? I mean, did it deal with that? There's an express right there of indemnity for the reasons you've given.
Well, they raised the question at 41. Yeah. they raised the question at 41, which is not quite my Lord's question, but it's an allied question. What happens in circumstances where the creditor actually knows that the trustee is acting in breach of trust or outside his trust powers? What happens there? And they don't provide a satisfactory answer to that with respect.
Yeah.
It is a real question, because the conclusion that you draw from the limited words that there are, that those rights of indemnity have been removed, and so the limitations on the rights of indemnity have been removed, does leave that and other questions to be resolved. Whereas if you approach the case in the way that we submit, the position goes on, as it did before. There are rights of indemnity and exoneration, but they're limited. That could give rise to a subrogated right, but what the statute wants to make clear is in the example that it gives in A, the right is limited to that of the trustee.
So the provision, in effect, is weakening the position of creditors rather than strengthening it, as the Court of Appeal suggests in paragraph 45.
No, my lord, it's not. It's not creating a new right or a new protection for creditors. It is strengthening the position of creditors, because it's saying even if the contract with the trustee doesn't contain a carefully drawn limitation clause. I'm sorry, I'm approaching it the wrong way. No, it is saying, it is strengthening the position of the trustee.
As against the creditor.
As against the creditor, as against the creditor.
But it's not, I mean, fundamentally, you say, altering the position between the trustee and the beneficiaries.
No, it's not. It's not. That's not, and so far as the trustee and the beneficiary is concerned, we see how that's dealt with in Article 26 and in Article 30, which deals with breach of trust. Lord, I have to say something about Article 26 because there's a part that your Lordship haven't got, and I've got 25 minutes, so if your Lordships will forgive me.
Yes, of course.
I want to move on to that. Yes, Perkins is rightly saying that it may indeed be quite right, and my Lord Hodge is right to say the creditor's position may be weakened, but the creditor knows where he is and is therefore in a position to take security or not to enter into the contract in order to protect or avoid the position.
Or I suppose to require that the trustee contract also at the risk of his personal estate.
Yes, or take a guarantee.
As would be the position at common law if there was no restriction.
Yes, my Lord, or take a guarantee from the beneficiary, all sorts of possibilities.
Yeah.
He would know where he stood, so it's helpful in that respect. My Lord, if your Lordships, if I've, either through the route of Article 32 not applying, which is Mr. McQuater's submission, which I support, that it doesn't actually apply, or that your Lordships accept the interpretation I've put forward that Article 32 does not remove the need to go through the trustee's right of indemnity to get to the creditor's right, then the question arises whether or not there were liabilities reasonably incurred, the liabilities that are sought were reasonably incurred. And that's the question that neither court below dealt with, or rather answered in our respectful submission. So far as the Court of Appeal is concerned, what they said in the October 2014 judgment, they had said that this question doesn't arise because their reading of Section 32 was that it excluded this limitation, and therefore they never needed to consider the question. So far as Mr. Justice Chadwick was concerned, he avoided the question, not because he took the same view as the Court of Appeal, but because he took the view that it couldn't be said that these liabilities were not reasonably incurred, because he took the temporal position that that was a reference back to when the loans were actually entered into. And so neither considered the factual question. Now, as to our notice of appeal, because criticism is raised, in our respectful submission, wrongly, could your lordships look, please, at Appeal Documents 1, tab 3, and I'll give my lords the MS number to that. 13420. Paragraph 2.12. I may read, as a result of its conclusions in relation to Article 32, the Court of Appeal held, paragraph 76 of the retrial judgment, that it was not necessary for it to consider whether the liabilities of the PPI companies were unreasonably incurred or whether the former trustees acted unreasonably in failing to divest themselves of those liabilities. Such are issues arising only if the former trustees' right to indemnity had depended upon Article 26.2. In consequence, the Court of Appeal failed to deal with that part of RNH's appeal directed against the trial judge's conclusion that liabilities of which the former trustees had failed to divest themselves were liabilities unreasonably incurred within the meaning of Article 26.2. Further, given the trial judge's finding that the former trustees fell short of the anticipated high standards of professional trustees in failing to deal with the loans problem when entering into the Oscar-Taylor arrangement by means of the framework agreement, the liabilities to Glenalla and Thorson were thus unreasonably incurred. Now, we complain about this. I'll take my lords in a moment to the important paragraph in Lieutenant Bailiff Chadwick's judgment, and we'll ask your lordships to consider whether, as we submit, it does in fact contain a finding that the former trustees' liabilities were unreasonably incurred. But before I get to that, can I just deal with really what's being said on our notice of appeal? It would be preposterous if all we had done in our notice of appeal was to try to clarify the law of Jersey or Guernsey either. All we'd done was to try to clarify what the trust law meant and hadn't wanted to go on and therefore get the next step, which is, and applying it properly, not in the way that the courts below did, these were liabilities not reasonably incurred and therefore they cannot be visited against the trust estate. So far as the Bailiff Chadwick's judgment is concerned, would your lordships take, please, paragraph 247 of his judgment. Mercifully, there's only one, so I don't have to have to identify which one it is. Paragraph 247.
Page.
Just turning it up, my lord, to get the reference. Is page 257. MS 257 and internal number 257. Now, I'll invite my lords, when they have a moment, just to look at this paragraph in its context.
Sorry, can you give me the MS number?
247, my lord, and page 257. Paragraph 247, in its context, and my lords can see, for example, just by looking at 246, what the learned judge had been doing was going through a number of allegations and asking the question whether the former trustees were negligent or grossly negligent. So one sees that, for example, in the first paragraph of 246, which is on page 256. Then in 247...
Well, isn't he, at this point, he's really focusing on gross negligence. This is his issue 7, and that's why he sort of says even if negligent, nonetheless, it can't be categorized as gross or serious.
Indeed, he says it's not gross, but he does criticise.
Yeah, he does criticise them, and you're going to refer to 247, are you?
Exactly, he criticised them, and we say it actually amounts, at least in context, and he himself, we say, says this later.
And 251.
And 251. Yeah. So he is saying they were negligent. They were not grossly negligent, but they were negligent. And
by which words in 247 are you focusing on now?
I'm focusing on, I suppose...
It's sort of the high standards.
Yes.
Well, it's a little...
It's the
yes.
whole context.
Their failure in that respect cannot, in my view, be described as amounting to a serious and flagrant
Yes.
degree of negligence.
So not serious, not flagrant or serious. So doesn't get to the gross negligence threshold, but it is negligence. And we have a little further insight into that. If your lordships could possibly take the record volume 8, which is my lords, which is at page 5901, the MS page, but also the bundle page.
Same, would it?
My lord?
Would it be the same, 5.9?
Should be the same. Well, there's internal pagination too, so I'm asking my lords to go to 5901, which is the MS number. It's 4984 of the internal bundle.
Yes.
And there's a passage, this is in the context of a discussion that's taking place about the potential appeal. And your lordships will see a passage which starts with Mr. Wessel's at the top of that page, and then towards the end, the Lieutenant Bailiff says, "Yes, and he's appealing against my failure or refusal to find that I did not, despite your rather optimistic suggestion in your skeleton, find that you were not in breach of trust. What I found was that you'd not committed a gross breach of trust sufficient to disentitle you to rely on the Armitage and Nurse clause." So
That's a double negative. I'm not sure that the positive necessarily follows. Because back at his paragraph 251, he says, but even if something could have been done at the time of the framework agreement, as to which he's impliedly making no finding one way or the other, it was too late by the time they tumbled to the problem.
This does appear, notwithstanding that, my lord, does appear that Lieutenant Bailiff Chadwick was saying when it was being put to him, "Oh, you didn't find this," he's saying, well, that's pretty optimistic. And we derive from that support for what we read in any event from 247 and 251, that he did find that, though he doesn't spell it out. Now, and there was ample grounds for him to do this. Your lordships have got the point, I know, which runs through actually all of these appeals, that the critical failure was to achieve, through one route or another, the protection of the assets outside what was called the Oscatello structure from liabilities. It was to be non-recourse, and we have, we say there's a lot of evidence about that, but if your lordships would take just one document, there's at record volume 2, which is MS page 1874.
Sorry, MS.
1874. This is an email that's sent a week or so before the framework agreement is entered into. And it's from a lawyer at Linklaters, who were the solicitors for Calpting, to solicitors at Kirkland, who were the solicitors for the trustee. And your lordships will see on the next page, which is page 1875, paragraph 4, there's a reference to the PPLs. Those were the profit participation loans, which are part of the structure. And the reference is, as discussed, Calpting agree that their recourse in the deal is simply to REH1. REH1 is then Oscatello, that's how it was described at the time, and that they do not have any recourse to TDT or other R20 companies. Now, we say there's a lot of evidence that that was the deal. There was issue as to the extent to which the trustees recognise that. They certainly should have done. And in the judgment at paragraph 247 that we've been referring to, your lordships will have seen the reference by the learned Lieutenant Bailiff to there was a problem. What was the problem? And the problem was precisely this, that the assets outside the Oscatello structure would or might be exposed to claims by counting. Well, that's the situation in which we now find ourselves. Can I just make one point, lest there
Well,
is
indirectly, because Kaupthing claims against the creditor companies,
and goes through.
which were within the Oscatello structure.
Yes, but what had happened was, putting it very shortly, the former trustee had lost sight of the fact that there were there's intercompany indebtedness. And the intercompany indebtedness means that if they then take charges over companies which are the creditors under that indebtedness, they can then...
That's what I meant by indirect.
I'm sorry, my lordship was absolutely right.
Yeah.
Absolutely right. That's the problem. Can I just make this clear, just in case there's any misunderstanding? None of the assets currently within the trust are sort of derived from the Kaupthing loan, the one that loans that they're trying to recover. I think there may be, I'm not making that quite right. No, I think I am. I think there may be an assumption that what's happened is that monies have been borrowed, assets have been acquired with those monies, and it's then attempted to protect those assets against that indebtedness. That's not the situation. The assets, for example, Mr. Cengiz's home, were not acquired with Kaupthing monies. They were acquired in other ways with loans from other banks, which are still in existence. So that's not relevant to the law, but just in case there was a misunderstanding in relation to that. We can see, for example, that there is, I don't invite your lordships to turn it up, but there is in the record a careful memorandum. It's at volume 7, MS 4556, 4564. It may start at 4560, 4550. It's a careful memorandum from...
You said again, 4, 5...
I'm going to get this right this time, because I've got several...
Yeah.
I've got to find the starting page. It starts at 4537, record volume 7, 4537. But it's a memorandum, a careful memorandum from solicitors for the former trustee, which has been disclosed, and which sets out a number of factual issues, which demonstrates precisely why we say there was a failure by the former trustee to give the protection, to ensure the protection that was intended and should have been obtained.
Are you coming back to the construction of Article 26, or have you done it?
I've got to deal with the temporal point, if I may put it that way.
Oh, good. You're coming back to that.
We'll come back to that, my lord, yes. I just wanted to, your lordship's right to remind me.
Just remind us where Article 26 is again.
I beg my lord's pardon.
Just remind us where it is.
Article 26.
Yes.
It's in 23.
20428.
20428.
Oh, no, it's 22. Right, that's the further iteration. It's page 20428. But can I just conclude? I've got very little time. I just want to conclude what I'm saying about the facts and how your lordship should deal with it. Neither court, with the exception of the temporal argument, dealt with the fact as to whether it was not reasonably incurred. We say there's abundant evidence that it was not reasonably incurred, and indeed we respectfully submit that Lieutenant Bailiff Chadwick's judgment at 247 and 251 actually contains, fairly read, a finding that though not grossly negligent, they were negligent. And that would in itself indicate that the liability was not reasonably incurred. So
Well, that's begging the temporal question.
yes, that's what I'm now going to.
Yeah.
What I'm
So if we don't get to that point, what then?
If you don't get the...
If we can't find it in the bailiff's judgment, what then?
Well, you'll have to remit it for a finding if your lordships are of the view that it is something that needs to be decided because your lordships don't agree either with Lieutenant Bailiff Chadwick's temporal point or the Court of Appeal's rejection of Article 26.
But you've got some, haven't you got some factual hurdles in addition to the bare finding of negligence? But don't you, in this context, have to show some causative link to loss, or am I wrong about that? What do you say the position under 26 is?
To some extent, this may trespass on the retrial appeal, which I'm not supposed to deal with orally.
You've mentioned it.
But if that's a sin, so do my learned
I mean, if they link, we're not totally unsympathetic to the link being explained to us, but we're certainly not inviting.
No, I'm not. I'm not going to trespass on that.
If reasonably incurred, if the antithesis of reasonably incurred includes unreasonably failed to get rid of having incurred, whether you could in fact get rid of it because you couldn't have got Count-Thing's consent must be a factor in the mix, mustn't it?
And our position in relation to that, and that's where I'm saying, I think that's dealt with in the retrial. That's what's dealt with in the retrial appeal, is we set out our case as to why the suggestion that we couldn't have got rid of it is actually not justifiable. That's one has to find my submissions on that.
When it would, yes.
But was there evidence as to the precise financial circumstances of the various companies within the Oscatello arrangement in the period between December 2007 and October 2008? Was evidence led to show that the arrangement could be made without putting the companies into or some of the companies into insolvency, and therefore putting the directors in breach of their fiduciary duties to those particular companies?
The question was whether Coupting would have consented.
And that wasn't my question. My
I know
question
that, my Lord.
was a separate one.
And I can't answer my Lord's question. There's someone around may be able to. The key question was whether or not Coupting would have consented.
Mm-hmm.
And
Do you accept, I mean, that assumes that Coupting's consent was required, but you're accepting that?
I think I have to, my Lords, because what we're saying, we're saying that because we're saying that
Would have been a restructuring, and Coupting would have understood why, just as we saw that memo. That memo just goes to, one will need to look at it more closely, but what does that go to as a transaction?
It goes to what the former trustee did and didn't do and should have done in relation to this very transaction, the framework agreement.
But in your retrial appeal, you're attacking in limine the Coupting wouldn't have consented finding, which for the Lieutenant Bailiff's purposes was really they wouldn't have consented at any point in time after the trustees actually tumbled to the problem. This is a subset of that question, or possibly a separate question, which is whether they would have consented before the trustees tumbled to the problem, isn't it? Because the judge has found in the paragraphs you showed us that Coupting, that once the trustees tumbled to the problem, it was too late to get Coupting's consent.
But
you challenged that in the retrial.
We challenged that.
Yes. But this is a different question, isn't it? Because it's you say, well, the Lieutenant Bailiff made no finding about whether Coupting would or would not have consented between the date of the making of the framework agreement and the date when the trustees tumbled to the problem.
And we did adduce evidence. It's referred to evidence from Mr. Cengiz and Mr. Smalley that they believe that Coupting would have consented, and they give their reasons, though.
But I think they give that right across the pitch time-wise.
That's true. That's true.
Yeah.
This is what, just tie the period down more precisely. It's in the period between about August 2007 and December, is it? It's that period. Or is it, no, it's later on. No, sorry, it's later on. It's
December,
yes.
it's December to...
The framework.
Yes, it's December. No, it's the framework.
December to August, to October 2008.
Yeah, sorry.
Until then, there's no structure into which you could have isolated the debts.
I'm sorry, I'm hesitating whether that's right, because the loans are novated. When are the loans novated? The loans are novated in August, and at any time between August and December, there could have been a change which would have meant that what happened was what should have happened, we say, which is that the loans should have followed the companies. Companies are being moved, the loans should have followed those.
But the asset only moves to Oscatello. The asset consisting of the ownership of those subsidiaries only moves to Oscatello under the framework agreement.
Yes, indeed.
December.
Indeed. But
Isn't that when you say the loan liability should have been dealt with?
yes, it is. I'm just saying you could have actually, it seems to me, you could have restructured before then so that the liabilities were with the company. But in any event,
But there is a finding at 246 that the former trustees weren't negligent, let alone grossly negligent, in December. And therefore, any implied finding of negligence on which you rely must post-date December.
well, my lord, that's specific to the allegation of negligence in requesting or acquiescing in the payment by Oscatello of their indebtedness to
Ah, yes,
limited to
that is true.
It's 247 that deals with the point.
Yes, thank you.
And we don't have from the learned Lieutenant Bailiff a recitation of the facts and the evidence which one might have hoped for, which might enable some of these questions to be more clearly identified. What we do say is that he avoided the analysis by the temporal point, which I will come to now and must deal with before I sit down.
But isn't the asset which you say that, I think your basic position is that the debt should have been dealt with at the same time as the assets were passed on.
Yes.
So you shouldn't be getting rid of assets without at the same time getting rid of the debt.
Yes.
The asset in question is the shareholding, isn't it, in the two subsidiaries, which are the creditors. And those shares were only transferred by the framework agreement to the Oscatello structure.
Yes.
So at the moment, it's short of some sort of allegation that the Oscatello restructuring should have been done earlier than December. I'm not quite sure why the asset has moved at any earlier date than December, justifying a complaint that the trustees should at the same time have moved the debt. Because that's when the shares in those subsidiaries were sent to the Oscatello structure, I think.
There's no finding by the learned judge. Let me put it this way. Certainly, if the trustee had acted as it should have done, it would have made sure that at the time of the framework agreement, this problem had been dealt with. Miss Bleasdale talks later about the problem being dealt with. This is the problem. It should have been dealt with by then and could have been dealt with, we say, as part of the restructuring arrangement and should have been, and our evidence was that Kaupting would have consented. Now, I can't say there's a finding that they would have consented because the learned judge didn't then go into those issues. He avoided the question by his temporal approach, and that I do want to deal with. Lots I want to deal with, but I know it's very limited time.
I mean, you've got a strong, that memorandum you showed us at 1874 is a strong indication, you say, that Kaupting was laid back about
yes.
limiting its recourse.
Yes, indeed, and Mr. Cengiz and Mr. Smalley sort of give evidence of the course of dealing, that it was the usual course was to take the loans with the companies.
And the PPLs, that's the whole of the revised borrowing, is it?
No, it's just a part of it. It's the profit participation loans.
Not all the loans were that. Right,
So, I mean, the temporal question, we pose a number of possible examples, and one is where what's his temporal note? One is where, and there are a number of examples, a liability is, as it were, entered into in the sense that a contract is made reasonably, but then events take place afterwards, which means that a liability is incurred, which is unreasonably incurred. So, for example, so the trustee enters into a perfectly reasonable contract, but he then unreasonably breaches the contract, giving the counterparty a right to claim damages. The counterparty brings that claim for damages. Well, it's obvious that the liability to the counterparty, which is the damages, was unreasonably incurred. That's one example. Secondly, the trustee enters into a perfectly reasonable contract. It's breached through no fault of his own.
That's because it's looking back, essentially, from the moment when some claim to be indemnified or to exonerate arises. You ask, is this reasonably incurred liability?
Yes.
Look back at everything.
Yes, and the contract may have been okay, but you breached it, or you failed to take advantage of a breach of an escape clause that you should have done to avoid the liability.
May it be said against you that there is this distinction between a liability actually incurred, which may be a damages liability or a debt liability. The damages only is the result of a breach, a debt's the result of the debt which it creates. And the failure to get rid of that liability when an opportunity arises, that the latter might be remediable by way of a claim for breach of trust, which is separately preserved in Article 32.
It is separately preserved, but that may not assist. I mean, the beneficiary should not be exposed to finding the trust asset applied towards satisfaction of a liability that was, in broad sense, unreasonably incurred, whether it was the original entry into a contract, it was the failure to trigger an exempting or escape clause at a later date, or was causing a breach to take place which caused the damages. I mean, we can't see with respect what the difference in policy and principle terms is between those cases. Obviously, if something happens at a later date, when it comes to the question of reasonably incurred, it may be that the fact that it's a later date then comes into the equation as to whether it's reasonable. And the principles I was describing earlier about the right of exoneration also give rise to the way this is seen in practice, which is the accounting which takes place between the trustee and the estate. And I can give your lordships two references to this. Exall Cole, I won't take it up, but volume 28, tab 382, page 30593.
Sorry, what say it again?
30593. And it talks about, particularly at 30594, about the accounting of the trustee. And Stott and Milne, which is at page 31080, volume 29, tab 418.
Sorry, could you give me that number again?
That
Second one.
My lords, 31080, volume 29, tab 418, and a decision called Conway and Fenton, which is at 21, tab 275, at page 27851, at the last paragraph on page 27857, which talks about the mechanics of how the account takes place. So the obligation to account goes on, and you would be looking whether or not, if you come to the account, whether or not particular liabilities have been reasonably incurred. I'm not going to develop submissions on applicability. Our position is stated in our written case, and I've made it clear that viewed as in the contractual way, we agree with Mr. McQuater that the Jersey law would not apply. Unless at any point your lordships would like me to try to address, I'll say no more about that. Equally, I say no more about the costs appeal. Our submissions are in writing. I don't think I appreciate it. Past my time.
Right, yes. Thank you very much indeed. I haven't been invited juniors to speak, but the speaking list indicates that they're not going to speak. Let us move then on Mr. Tao.
May it please your lordships, we've departed from the agreed timetable, so I've lost 10 minutes so far. My lords, you have our written case, which is in the document, volume 2, tab 32, and from time to time I will refer to it. It's MS 14151 is where it starts.
4151.
My lords, before the Lieutenant Bailiff in Guernsey, at the hearing in June 2012, the position of the former trustees was that they did not dispute that they were liable as trustees in relation to the Thorson and Glenalla debts for 80.5 million and 78 million euros. The issue was whether they were liable in their personal capacity. And they have maintained consistently two defences to their liability in their personal capacity. The first was that as a matter of the construction of the contract, it was clear that they were transacting only as trustees and not in a personal capacity. And that could be inferred from all the surrounding circumstances. I should remind your lordships that there were no formal written contracts recording the loans from Thorson and Glenalla to ITGL. We will look at what the Guernsey Court of Appeal described as telegraphic documents, which are basically transfers from the company to the trust account. And there were some accompanying resolutions in some cases, but not all, by the companies and by the trust. But in those informal contracts, nothing was said about proper law. Nothing was said to the effect that the trustees were personally liable. Indeed, the transfers were made to the trust. The second defence, which is what we're concerned with on this part of the appeal, was that under Article 32, subparagraph 1a of the Trust Jersey law, which is the proper law of the trust, Jersey was the proper law of the trust. So Article 32, 1a applied to, with the effect that the trustees were not liable in their personal capacity for the debts to Thorson and Glenalla, but only in their representative capacity as trustees. As a matter of the true construction of Article 32, the former trustees say that they were not liable in a personal capacity, because that is the effect of Article 32, subparagraph 1, but only in a representative capacity as trustees, and only to the extent of the trust property. And as regards the applicability of Article 32 in the Guernsey Forum, the former trustees say that the private international law rules of Guernsey provide for the court in Guernsey to treat the issue arising on the former trustees' defence as one governed by trust law and specifically the trust law of Jersey. And one finds that, as I will explain in due course, in the provisions of the Trust's Guernsey law. So can I deal first of all with the interpretation of Article 32?
Yes, can you give us a reference just to the Guernsey Trust law on that point?
My Lord, I'll
Will
take
do.
your Lordship
Right, yes.
through the provisions in considerable detail.
Right, yes. Right.
Now, as regards the construction of Article 32 of the Trust Jersey law, it has been common ground all the way through, and it was in the Court of Appeal, that one had to understand its origins by reference to the common law problems that existed where a trustee transacted with a third party. And the essential problems were these. First, at common law, the common law courts would not distinguish between the individual acting in his capacity as a trustee and on his own personal account. That's because the trustee, in his capacity as a trustee, was not a juridical person. So procedurally, at common law, an action could not be maintained against the trustee in his separate representative capacity. And the second problem was that at common law, ordinarily, the third party who obtained judgment against the trustee on a debt arising in his representative capacity could not enforce directly against the trust property. And some surprise was expressed about that proposition, but it's illustrated, is described in the Court of Appeal Authority in Jennings and Mather, 1902 1 KB 1. One finds it at pages 5 to 7 of the authority. It's in the authorities bundle at 25328, MS number 29481. My lords, that was common ground before the parties, between the parties before the Court of Appeal. As I understand it, it's common ground here, so I'm not going to take your lordships to it, time available. The two problems I've just described were well known to trust lawyers. Relatively early in the century, there's a famous essay by Scott, the editor of Scott on Trusts. We've given you information about the academic writings on this. Probably the best place to look is in Scott on Trusts, the third edition, which is 1959. And it's in the Authorities Bundle 32465, MS 32055. But I hope I've described accurately already to your lordships what's said there about the common law problems. And inevitably, where you have this tension between whether a trustee is acting in a personal capacity or a representative capacity, there could be uncertainty as a matter of contract, and your lordships have already been shown some authorities, the kind of problems that could arise. But the real vice of the English common law rules was threefold. First, the rules could operate unfairly to judgment creditors if the trustee's personal property was insufficient to meet the claim. Obviously, it could also be potentially unfair to trustees if the trust property was insufficient to meet the third party's claim. Your lordships heard how, under English law, it was necessary for a creditor of a trustee who had been acting in his representative capacity to enforce a judgment in a roundabout way. He couldn't do it directly against the trust assets. Instead, he had to take advantage, first of all, of the trustee's own right of indemnity out of the fund, and then claim to be subrogated to it. And that had to occur in an administration action in the Court of Chancery.
Form of equitable execution is how it's described in some
Exactly.
places.
But that did not always operate fairly to creditors, as your lordships will have seen from Re Johnson. Because let us take the example of the banker who lends the trustee, as trustee, £100. That may be a perfectly proper loan, but when he comes to enforce the banker against the trustee, he may discover in the administration action that in a quite separate transaction which the trustee has been involved in, he's committed a breach of trust, and he's liable to pay £100 back into the trust fund. And therefore, the banker's right of subrogation through the indemnity of the trustee is worthless, because until the trustee has restored £100 into the fund, he is a debtor of the fund, and the banker can be in no better position than the trustee. So that operated unfairly to creditors, above all because they couldn't know what the position was as a matter of account between the trustees and beneficiaries in their dealings. Obviously, if the transaction itself was an authorized transaction, that was a consoling matter. But it wasn't an answer to the injustice represented by the case where the trustee was liable to the beneficiary on a quite separate matter. And that was the problem which commentators for over 100 years have been aware of. You'll find it again, as I say, we've put some material in the appendix to our written case dealing with this. And it's at MS 14223-4. I've cited the 1959 edition of Scott on Trusts plus a supplement in 1981. We've referred to the English Law Reform Committee's report in 1982, which referred to the uncertainties that existed.
Can you give me the MS number again?
I'm so sorry.
14223.
14223-4. That should be pages 73 and 74 of our written case.
Yes.
And, my Lord, in the bundle you can also find...
That's really starting at paragraph 14, is it, right at the bottom of 73?
I hope so.
Yeah, well, all right.
Yes.
It's just the rest of the page doesn't seem to have anything to do with it.
One can also find it in the then current edition of Underhill in 1979, Underhill's Law of Trusts and Trustees, which is the 13th edition, at page 682, and it's in the bundle at MS 26487, which explain the problems caused by Re Johnson, the potential unfairness to creditors. Now, the former trustees' case is that given that these matters were well known in the common law world, it would be surprising if they weren't in the minds of the legislature in Jersey in 1984 when they first produced Article 32, or its precursor, which was then called Article 28. As I understand the arguments of learned friend, Lord Goldsmith, his position is that in many respects Article 32 has left the common law position largely unchanged. I think he accepted today, although it wasn't clear from written case, that Article 32(1)(a) could, in the context of a Jersey proper law trust, mean that a trustee was not personally liable in relation to obligations with a third-party transaction with a third party. I'm not entirely clear where we are on the quantum cap argument that was originally put forward. But we say, former trustees say, that the Court of Appeal got it right in their construction of Article 32 if one looks at the background. My Lords, may I invite you to go to Article 32. It's in MS 20430. And as has been pointed out, it creates a contrast between the two types of third party that transacts with the trustee. In A, one has the knowing trustee, the knowing third party. That's to say the third party who knows that he's dealing with a trustee and the trustee is acting in the transactional matter as a trustee. And on the other hand, one has, might call the ignorant third party who doesn't know that he is dealing with a trustee of a trust in the matter. And we submit that the construction of Article 32 is assisted by looking at the contrast and the implications of the contrast between B and A. And in the case of B, this is the case of the ignorant third party. The position is that the trustee is still personally liable, and that's what one would expect to be the case. If the third party doesn't know, is not informed by the trustee that he's dealing with a trustee, why should there be any departure from the ordinary position? But the bracketed words indicate that without prejudice to the trustee's personal liability, the trustee shall have a right of recourse to the trust property by way of indemnity. So even in those circumstances, on its face, Article 32(1)(b) gives the trustee an unrestricted right of indemnity in the case where he's been transacting with the ignorant third party. Now, my Lords, your Lordships saw yesterday that when this provision was originally enacted in Jersey, after the words by way of indemnity, there had been the words unless he, that's the trustee, acted in breach of trust. So originally the statute had contemplated that the trustee's right of indemnity for his personal liability in a transaction with an ignorant third party would be lost if he acted in breach of trust. But the Jersey legislature, as you heard from a learned friend in 1980...
It didn't say unless the liability arose from a breach of trust, though, did it?
No, my Lord, it said unless he acted in breach of trust.
Yes, which is capable of going far further than would be logical. Why should you lose your right just because you've made some minor breach of trust which hasn't had any effect on the creation of this particular liability?
Well, perhaps as a matter of implication, it was concerned with the case where the transaction itself was a...
Well, I was going to say, that's what I was asking about. I mean, if it meant that, maybe it would make more sense. But one's asking why, I suppose, why it was deleted.
My Lord, yes. Yeah.
I mean, it's a rather blunderbuss-like bit of statutory phraseology, isn't it? Overlaying what previously, on the assumption that the English common law and equity apply, was a slightly more nuanced position. That the trustee would have to make good his breach of trust first before he could rely on his indemnity. But it wouldn't kill his indemnity off altogether. So if it was a minor breach of trust, he could remedy that, and his indemnity would, as it were, revive. I wonder if they got rid of it just because it was really an awful old blunderbuss and it was better just to rely on the underlying law. Well, because you wouldn't be able to spell that just out of those words, but you might well do if you understood what had been there before.
Oh, could I think about this? I haven't thought of that possibility. Could I reflect on it a bit? Yes.
But isn't it covered by subsection 2, or is that something different?
Well, it obviously, subsection 2 is dealing with the separate situation, which is the position between the trustees and the beneficiaries, obviously. And
well, so is the right of indemnity, which was to which this previous phrase was tagged. So where do we find the old version of Article 32, the one you're referring to, the 28 as it was?
my lord, I'd have to.
This one.
I think it's 20473. That's it. It's in tab 23.
Article 28.
Yeah.
Yeah.
Yes, so well, I mean, it's been replaced by a more logical, one might think, instead of a precondition, it's now a preservation of any other right that may have existed. But it doesn't seem to, I mean, you say it follows that the Court of Appeal is right, that the indemnity is automatic, irrespective of fault, but is that the case?
This is dealing with, this whole Article 32 provision is dealing with the position of the creditor and what happens when the creditor seeks to enforce his judgment against the trustee. So what would happen in the administration action as between the creditor and the trustee?
But yes.
Subparagraph 2 is preserving the rights of the beneficiary.
As a bracket, it is dealing with the position of the trustee and saying he keeps his right of indemnity, but then 2 is saying he's still subject to breach of trust.
Exactly.
That seems quite logical.
But is there any reason to believe, I mean, that the right of indemnity is any different from the one which they would have at common law?
Yeah.
In other words, it would be dependent upon them whether there was causative fault.
Well, what I was suggesting was that there are 2 separate issues here. One is the question of what can the creditor do to get at the trust property, and the second is what is the remedy for the beneficiary if there's been a breach of trust. The beneficiary, if there's been a breach of trust, can sue the trustee personally for the breach of trust and recover compensation. In other words, one of the purposes of highlighting the contrast was to draw out the other point that emerges, is that where the trustee is dealing with the ignorant third party, of course, it says that the trustee is personally liable. By contrast, in A, the trustee is liable as trustee, and the claim shall extend only to the trust property. So what we say, and what the Guernsey Court of Appeal found, was that this contrast highlights that the trustee dealing with the knowing third party, who knows at the time of the transaction that he's dealing with a trustee, must accept that his claim is going to be, if he has to enforce it, against the trustee in his representative capacity, and he's got to look to the trust property to satisfy his claim, not against the trustee personally. So we do say this made a fundamental difference to the law in England, because the Article 32 1A position, when you're dealing with where you have a dealing between a trustee and a knowing third party, from the outset, from the time of the transaction, the third party knows that his claim is only going to be against the trust property, not against the trustee's personal property. And we say that it follows from that that It cannot simply be a matter of the provision in 1A doesn't discharge personal liability of the trustee. What it says is, from the outset of the transaction, he's not personally liable at all. He's only liable in his representative capacity. And so when it said that the effect of the Article 32 is to discharge a liability, we'd respectfully submit that's wrong. There is no personal liability.
Well, I mean, I think that's a semantic point, isn't it? If you had a statute in Metlis type or Adams type case, the Greek bank cases, which had said at the outset that no Greek bank making contracts shall incur liability beyond its core capital or something, and a bank enters into an English contract, well, that's not a discharge, but it's simply, on one view, an irrelevant provision because it doesn't strike. I agree, we're getting into the conflict of laws issues here, but...
I'll come back to that, my lord.
Come back to them, but that's the problem.
The case is about subsequent discharge of a pre-existing liability. And the temporal point's not wholly semantic, my lord. The point is that as a matter of construction of Article 32, there is never a personal liability of the trustee to the knowing.
But that's if you're contracting by reference to Article 32. Does everyone who makes a Guernsey contract with a Jersey trustee focus on the Jersey trust law? Are they supposed to?
Well, my lord, I will submit they should be, and that flows from the status of these rules under the laws of Jersey and Guernsey, my lord, yes.
We're still at the moment, we're simply on interpretation.
We are,
right?
yes.
And how does it work, and then where does the breach of trust come in? I mean, the creditor is going against the trust property and stuck with that, although he doesn't have any knowledge of any breach of trust there may be, and to the extent to which the trust property is depleted as a result of that, he will have no knowledge of that, will he? And that's just a problem. Too bad.
He takes it for whatever it's worth at the date of enforcement, presumably.
He's got, yes.
Yeah.
Well, and he has to queue up with anybody else in a similar position.
Exactly.
Yes.
I mean, there may be 10 of them, all
My lord, yes.
subject to Article 32,
My lord, yes.
competing for a slice of the assets of the insolvent trust, by which time, presumably, the trust will have to be administered as in insolvency.
My lord, yes. That's what's going to
That
happen
makes
in
it
this
rather
case.
a dangerous thing to transact with a Jersey trust.
Well, my lord, is that right? The
I don't know. I've not had to do it. Fortunately.
well, can I just develop this point? Because if, as in this case, you lend £80 million to a company which has got a balance sheet value of, say, £1 million, you know that you're not going to get anything from the personally beyond £1 million. You have to look to the trust assets for the purpose of recovery. If you're going to ask yourself, can I safely do a deal with this trustee, with this person, I have to look at the trust property. I've got to look at their terms of their trust. And that's the same when one deals with other entities or other types of people in a legal relationship. And I'll come on later to the position of the limited partnership.
I mean, the reason I'm raising it is because obviously it's terribly important for trust. I mean, Jersey trust law, it is fairly fundamental in Jersey. We need to be pretty clear of what the implications are.
Lord, yes, no,
I'm saying. And if the result of what we decide is that no one's going to want to contract with a Jersey trustee, that wouldn't be very satisfactory for them.
My lord, I don't think that's likely.
No, well,
I mean, taking the example I've just given, one has to look to the trust property rather than the personal wealth of the trustee, particularly with these very large Guernsey and Jersey trusts.
Well, I suppose it depends Depends on the, yes.
I mean, in a banking context, though, the reality is they're going to take security over the trust assets, which the trustee, as the legal owner of the trust assets, will be in a position, providing he's acting in accordance with his trust, to charge.
That is a question which...
And that's what happened here.
That's what one has to do.
Does it slightly depend on whether the trustee is a big company like Investec or not?
No, my lord, I don't think it, with respect, it does. In the end, most trust companies don't have large balance sheets.
Yeah.
So insofar as the exclusion of personal liability of the trustee is concerned, is there not a danger that the trustee, knowing he hasn't got personal liability, might behave in a way towards the creditor that he otherwise wouldn't? Or is that something that you say is covered by the sensible lender taking security over the trust asset?
That's one way to do it. There are a variety of ways to deal with it. One is, as Lord Briggs has suggested, also he needs to satisfy himself that the transaction that's being entered into is a proper one by looking at the trust deed. And that would be something you have to do in England too.
I want an opinion of local council. Suitably insured.
For what that's
suitably insured.
All right, for 80 million. So that's something which, where the knowing third party is dealing with the trustee, has to be resolved in the ordinary way as a matter of contract. There's no real difference in this sense that one needs to work out the value of the covenant of one's counterparty if you're a third party.
Yes, so you say if you know who the counterpart is, then you look to that particular counterpart for their covenant.
Yeah.
Yeah. Okay.
Now, my lord, could I also highlight something else which emerges from the language of this section, which is this contrast between the trustee dealing with the knowing third party and the ignorant third party. In our submission, one has to look at the position at the time of the transaction. That's to say, in the contract case, the contract, which would be the most common sort of case. And that's implicit in the section. Because let us imagine that the trustee enters into a contract with an ignorant third party, and then only tells him just before proceedings are issued that actually I was a trustee. We respectfully submit it couldn't be right in those circumstances that the trustee could take advantage of these provisions. And the Guernsey Court of Appeal reached the same conclusion at paragraph 28 of their judgment. And so it also deals with the argument that the BVI companies have mounted that after a contract's been entered into, the status of the trustee could have been changed by change of the proper law or something. The statute looks at the position, the date of the transaction, and what is the state of knowledge of the third party at that point. And that, again, is consistent with party autonomy and fairness. A further point which emerges from looking at the language of the section is that it's not a rule specifically about contracts. It's a rule about the third party dealing with a trustee in any transaction or matter affecting the trust. So it could, for example, apply to limit the liability of a trustee in tort or in restitution, any other form of obligation arising out of a transaction or matter. And that's why we say it has to be viewed in its context as a rule of trust law, not a rule which is about contracts. It's looking at the position as a matter of trust law of the trustees' relations with third parties generally. And I will be submitting the context of the private international law.
Yeah, isn't that slightly ambitious? I mean, I don't know whether it's ambitious or not, but it's a slightly far-reaching submission. Where a trustee is party to any transactional matter affecting the trust, is that really dealing with trustees who act tortiously against third parties?
Well, my Lord, I would respectfully submit it does. It doesn't say where he's transacting. Where he's contracting. It says where he's involved in any transaction or matter.
Party to any transaction.
Party to any transaction or matter.
Even more interesting conflict of laws problems if it's supposed to catch tort.
Well, my Lord, yes. That was the point I was going to make later on.
Well, I mean, maybe it's the difficulty is that this is a article which is stuck in the middle of a trust law, and it's sui generis, isn't it? It's a pretty unusual type of provision.
Well, it's unusual to an English lawyer, my Lord, with respect.
Quite common in other.
It's quite common in other jurisdictions, my Lord.
Right.
My Lord, is that a convenient matter?
Yes, we'll resume at 10 to. Thank you.
10 to.